Oh, yes, I do. Thank you for the present. Yeah. Sign here. No. Valuable. Thank you. Oh my goodness, that's like 2, 3. Yeah. You're not shut down. Okay. Where do I put this? I'll need some others later. Oh, that's right. I can do the same thing. I'll just use the file so yeah. That's for the second one. Okay. That'll be alright. I can load it up. Ready to go? Lovely. On new clip and it works this time. It's great. Oh, you took it in the film? Oh, that's a good idea. I was taking the phone out of the pocket. Okay. Okay, welcome back everybody. Good to see you. What a lovely room this is. I've got two lovely computers set back at the right angle. Okay, so today we shall be reviewing the first element, sexual element in the formation of a contract. You know what it is, agreements. Good. And then we'll be getting on to the second important element, that is consideration. Okay. Some parts of consideration are quite easy, other parts quite difficult, okay? But I'll do my best to make it as understandable as possible, and they are very important, some important cases which you understand if you know some must-know definitions. Okay? So it's like drilling for gold, all right? You can't drill for gold unless you've got a drill. Okay. And what are you drilling for? You're drilling for issues. What's an issue? Tissue without the T. Yeah, my goodness. Awful joke. I know. It's a question for the court to decide. So there's going to be an argument for and an argument against. Okay. Good. So we shall review agreement because we pretty well covered it last time. And remember, check your toolkits. In your toolkits, you at the moment have two must-know definitions, don't you? Definition of offer, definition of acceptance, which you all know and love because they're absolutely essential. What's an offer? An indication. Could be written, could be oral, could be by conduct actually, of a willingness to be bound on certain terms. Okay? And remember, that helps you explain what the case of Carlisle's all about. Remember, Mrs. Carlisle caught the flu, so she tried the smoke ball. Okay? Big question in that, was there a contract between her and the smoke ball company? And the big issue was there agreement? And in particular, was that an advertisement, an offer, or an indication of treat? Well, the court found it was an offer. Why? It was an indication by written advertisement. Willing to be bound, because they said in order to show our sincerity. Okay? If you accuse somebody of not being sincere, that's pretty bad, right? A sincere person is like, person in front, right? You're good? Yeah, look, see? A sincere person without wax. Well, it's true, right? So an indication, willingness to be bound. Also, in fact, they deposited £10,000, well, it was £1,000 in the bank. You're putting your money, okay, where your mouth is. And on certain terms. Good question. Was it on certain terms? In particular, what was the period for catching the flu and still being able to claim the reward? Was it while you're actually using the smoke ball? Was it, and this is when Mrs. Carlisle caught it, by the way, when she was actually using it. Or was it for a reasonable period after use, or was it during the pandemic? Okay. The court said, well, it's either the first two, while she's actually using it, or a reasonable period afterwards. What is reasonable? Well, the court said we can bring in expert medical evidence. Okay? expert medical evidence. Everybody relies on that. That's why we're looking for a vaccine for COVID. All right. And hopefully the powers that be in a certain country start listening to the medical evidence. But Hong Kong's pretty good with medical things. I mean, when we were here in SARS in 2003, I didn't recognise any students because just like you lot, you're all wearing a mask. You can recognise me because I've got a drop mine so you can hear me. Okay. All right. Okay, so that's the Carlisle case. And remember, the other important thing about Carlisle is that it was a unilateral contract. Only one party makes a promise. Unilateral, one-sided. Okay? So look how useful that definition of an offer is. It helps you understand a very important case in contract law. Okay? So I hope you don't catch the flu. I've actually been diagnosed with stomach flu. I'm full of drugs at the moment. So if I get spaced out, just throw something at me. Actually, I feel pretty good. They finally diagnosed it today. I've got the antibiotics and everything else. But I'm afraid my stomach's like an upside-down volcano. Watch out. You're lucky you're far away. Okay. Don't worry, I'll get through it. I'm fine. And actually, when I'm teaching, I forget all my woes. They say, what's wrong with you? Okay. So acceptance, of course, final and unqualified assent to the terms of the offer. So they've got to match, because remember, a contract is drawing together. Okay. It's not, if you're walking towards somebody to shake hands before COVID days, not much point. If the person's over there, you don't shake hands. You've got to meet. Okay. So that's acceptance. And of course, why are we talking about offer acceptance? Because of the Gibson principle, which says, hello, I've lost the PowerPoint there. The court will analyse existence of agreement in terms of offer and acceptance. All the time? No, unless there are exceptional circumstances, such as Clark and Dunraven's a good one. Two yachts collided. The boat owners had never met, so how on earth could there be agreement between the parties? But the court said they were both bound by the rules of the yacht club. Okay. And of course, exceptional circumstances might refer to complex commercial contracts in which it's often not easy to identify who makes the offer, who makes the acceptance. Okay? All right. So that's the Gibson principle, everybody. Must know, must know. Okay, if you don't, I give up. If you're answering the assignment question 1 and you don't mention Gibson, you'll probably fail. If you do mention Gibson, you're in a good position to come up with a good answer. Okay, all right. And then, well, you got there the definitions. Right, you know that. Must know. My suggestion is draw up your list of must-know definitions, your list of must-know cases, and your list of must-know principles. Okay? Good. And of course, Carlisle was a unilateral offer. Most offers are bilateral, two-sided, okay, where both parties make a promise. How do you distinguish between an offer and invitation to treat? Well, use your definition of an offer. Okay? And it does depend on the circumstances a little bit. If you are in a particular situation, like in a supermarket, okay, in which I was buying my chicken broth. I've had chicken broth, bread, papaya today. That was good. Oh my goodness. Display of goods on the shelves of a self-service shop. The court said for practical commercial reasons can only be an invitation to treat, because if it was an offer, as soon as you pick up the goods, you're accepting them. You've got a contract. You've got to pay for it. Okay? So nobody would be game to touch anything in a supermarket. Not because you might catch COVID. No, it's because you might have to pay for it. So for practical and commercial reasons, the display of goods on the shelves of a self-service shop, the court found, was only an invitation to treat. Okay, so next time you're in the supermarket, turn to the person you're with and say, reminds me of a case. What case? Pharmaceutical Society of Great Britain and Boots. Boots is quite a famous English pharmaceutical chemist shop or pharmacy. Good. All right. And then we've got these other ones. Partridge and Crediton, Fisher and Bell talked about displays, advertisements, or displays in a window. The court found only an invitation to treat, again for practical commercial reasons, because you're displaying it to the world. So 1,000 people might reply, but if you only got 100 items in stock, you're going to be in breach of contract to 900 people. Okay, and of course you know all about Carlisle. Sales of land, quite often the courts are going to be much stricter on whether there is a contract if the subject matter is a very valuable subject, such as land, right? But one thing we don't talk about on our course is that certain contracts have to be in certain forms, and contracts for the sale of land have to be in writing and signed by the parties, okay? And indeed, sometimes they have to be executed under deed, all right? The Gibson case itself, remember the Gibson principle, the court will analyse existence of agreements in terms of offer and acceptance, unless there are exceptional circumstances. The big issue in Gibson was, had the council made an offer to Mr. Gibson? The court said, no, they had not, because the letter from the council simply said, Mr. Gibson, we may be prepared to sell you your flat. Was that an indication of a willingness to be bound? The court said no. And then the other cases we don't need to worry about. So acceptance or counter-offer, again, know the definition of acceptance, so it's not final and unqualified assent to the terms of the offer, then it's not acceptance. So that's the simple result in Hyde and Wrench, because the reply qualified the term, namely the price. The reply actually does have some significance, though. The reply becomes the counter-offer. So that's what's on the table, so to speak. And the counter-offer can be accepted by the other party. Okay, good. This is a very powerful brew, I must say. I've got all sorts of things in here. Hello, don't explode. I should take out shares in Gatorade, because that's one of the few things I can drink. Right, good. Pumpkin soup, that's very good too, pumpkin soup, but has to be clear. So I've had a superb diet, thanks for an awful joke. You see, I'm not too bad, right? My jokes are pretty sick. All right, okay. You've got to have a sense of humour, right? Laughter's the best medicine. I know you're not laughing. Gentleman in front has many. Oh, that's a record for me. 12 minutes sleeping. The normal attention span's 20 minutes. Did you know that? So I've got to make sure I pack in quite a bit in the first 20 minutes, otherwise I've lost you. Okay, he'll come back, don't worry. We'll catch him on the second wave. Stevenson McLean, good to remember cases in contrasting pairs. So you have sort of similar facts, but with opposite conclusions. Because remember, what's an issue? Question for the court to decide. What's your argument? What's your argument? Is it Hyde and Wrench, or is it Stevenson McLean? Okay, so it's good to hang a case, so to speak, on both arguments. So in Stevenson McLean, the reply was simply asking for clarification of the terms of the offer. And the court said that that was not a counter-offer. Okay. It's very important, of course, when you communicate anything to be clear. That's quite important as well. And that's one of the skills of a lawyer. You've got to be able to express yourself clearly, all right? I mean, if you're on social media and say, I'm a law student, they'll say, wow, you must be good with words. And the answer is, yes, I am, including the gentleman who's arrived. Okay, I know the difference between law and equity. One of the maxims of equity, delay defeats equity. Okay, good. And the second must-know principle, okay, which in fact I've got in the next one. Acceptance must be actually communicated to the offeror. The Duress case is a must-know case. So you need actual communication of the acceptance. And then, of course, it often depends on the mode of acceptance, whether there is actual communication. And the onus generally is on the person sending the acceptance to make sure you get the message across. And you know whether your message is got across or not, depending on the mode of communication. So if you're on the telephone, you know whether you've got through or not. Okay? And similarly with telephone answering machines, etc. So usually the onus is on the person sending the message to make sure it gets across, including email. Okay? So that's in Duress. However, two big exceptions to the acceptance principle. A unilateral offer, because remember, how do you accept a unilateral offer? By performing the required act. Okay? So where's my swimmer? He's gone. Oh, he must be trained. No. Or what bad luck, my offer expired 6 o'clock the day after the last lecture. Because remember my example of swimming across Hong Kong Harbour. Okay? So the important thing, though, the tricky thing about unilateral offers is exactly what is the required performance and when does performance begin. Because once performance begins, you can't withdraw your offer. Okay, we'll talk about that a bit later. So you don't have to communicate your acceptance of a unilateral offer. You simply perform the required act. Mrs. Carlyle, what did she do? She performed the required act, smoking the smoke ball according to the instructions. Okay, good. And so, I mean, Mrs. Carlyle didn't call up the smoke ball company. Hello, my name's Mrs. Carlyle. I've seen your advertisement. No, she didn't have to do that. Okay. And then the postal rule in inverted commas. Okay, because remember the postal rule is not really a rule; it's an exception to the main principle. And I mean, it's outdated, it's obsolete, and you can easily rule it out. It's very easy to rule out the postal rule by simply making it clear in your offer that you want actual communication. By saying, anybody wishing to accept my offer, please let me know. Okay? All right. But examiners love the postal rule, so you must know the postal rule. What's on the screen, everybody? Probably should know rather than must know. Talking about the terms of the offer. If the offeror insists on a particular method, you can only accept by that particular method, full stop. So if you use any other method, that is not acceptance. Okay? However, if you only recommends a method, you can use any method that is no less favourable to the offeror. Now, that depends on the facts. Usually, if somebody sends you an offer by a particular method, you have to reply by another method which is equally fast. Okay, all right. And then, what happens if nothing is mentioned at all? Well, you can use any method, provided it is reasonable. It depends on the circumstances. Okay. I mean, most offers do specify a particular method. Okay. Please reply by email. Please reply by post, you can even do that. Or please reply by calling our hotline or whatever. Or visiting our website. Okay. I was awake at 3 a.m. last night, downloading the Quality Healthcare app. It took me 10 minutes, I had to get in the username and password. I haven't got those phones where you can use facial recognition, where you don't need username. Anyway. And then, of course, I wanted to do an e-booking. Sorry, no e-booking in Tung Chung. Well, that was good. Anyway, okay. So there you are. And remember, the general point is the offeror is the master of the offer. You can specify conditions. Okay? And if you don't comply with conditions, then that's not proper acceptance. Electronic communication, again, no universal rule in this area, says the Brinkerbon case, the House of Lords case. The courts generally will look to see whose fault it is that the message didn't get across, and generally it's the fault of the sender. Okay. And sometimes you don't know. So in an exam question, if you're not sure, use your magic two-letter word, if. Ta-da! What a powerful word, if is. Okay. If I win the Mark 6 lottery, if COVID is not here next year, I might be able to. I mean, what a powerful word, if is. Okay. All right. So there you are. And use that in examination questions. Because remember, in examination questions, like your assignment questions, you're given a certain number of facts, but not too much. And sometimes it's impossible to come to a black and white conclusion because you're not given enough information. Okay? All right. So when is email effective? I've given you the special one, this one. This is not in your course manual. This is for the assignment. Okay? So Chui says, it's a bit tough. The message is not effective unless it's actually read by the person it's addressed to. BP solicitor says only when it's accessible. Okay, so there's a bit of iffiness, if you like, in the law at the moment. So take it both ways. Okay? So the postal rule itself must know, says what? The postal rule says that acceptance is effective as soon as you put the letter in the control of the post office. When's the last time you sent a letter? Letters sort of going out the window, aren't they, these days? I posted a letter the other day and said, what do you do? What's that thing? Oh, it's an envelope. Oh, my goodness. What are you going to do with it? I'm going to put it in the mailbox. Why are you doing that? Because I'm an old guy and I don't like going to 7-Eleven paying my bill. Why don't you use Alipay? Oh, I get a kick out of touching a letter and writing a check. Okay. So there you are, the postal rule. So Adams and Linsell must know case, because you get a question on the postal rule, always mention Adams and Linsell, because that says what the postal rule is. But there are severe restrictions on the postal rule. It only applies to acceptances and nothing else. It only applies if it's reasonable to use the post, and quite often it isn't. Okay? And why do we have it? Well, the court's saying, way back in 1879, shows you how old this is, that both parties are treating the post office as their agent. So that's the rationale for it. And also there is a certain amount of business certainty. Okay? Now, when you're studying contract law, sometimes distinguish between domestic situations and commercial situations. Now, if you're in a commercial situation, businesses like certainty. Okay? Just watch the Hang Seng Index or the Dow Jones Index. When there's a successful vaccine, up it goes. If there's a little bit of doubt about the American election, down it goes. Businesses hate uncertainty. Okay? So there is a certain rationale here, and that as soon as you put your letter into control of the post office, you're certain you've got a contract, so you can start performing your obligations under the contract. Okay. But it is out of date, it's obsolete, it's only in academics' minds, and it's in every textbook on contract, and it could turn up in your exam. So yes, must know. But the important thing is know the acceptance principle. Acceptance must be actually communicated to the offeror and Torax. But we have these two big exceptions, the unilateral contract and the postal rule. Okay, good. And then last time we met, we don't need to worry about that one. The revocation of an offer principle. Remember, an offer may be terminated or withdrawn when? At any time before acceptance. Hayne and Cave must know case. There is one slight exception to that. If the offeree provides money to keep the offer open for a certain period of time, that's actually a separate contract called an option. And you wouldn't be able to withdraw the offer before that period. Okay, otherwise you'd be in breach of that separate contract. Okay, that's a special case. Otherwise, you can withdraw your offer at any time before acceptance. All right, so where's my acceptance person? You're in the same seat. You remember the principle though, right? Okay, good. Don't worry, you don't have to do it tonight. Okay. And the second must-know case is you can withdraw your offer at any time before acceptance, but it must be actually communicated to the offeree. Byrne and Van Tienhoven is a must-know case. So what's on the screen, everybody, is must-know, must-know. Okay. Good, so check your toolkits. 2 must-know definitions, offer and acceptance. 3 must-know principles. Gibson principle, acceptance principle, revocation of offer principle. Okay, they're the bedrock of your tools, if you like, to help you construct a good examination answer. Okay, but remember, tools are no good unless they are in good working order and you know how to use them. Okay, so I mean, like some people buy fancy smartphones and they know how to send and receive telephone messages and text messages. And maybe, but there are hundreds of uses of a phone, right? Do you know how to use them? I don't know how to use everything on my phone. All right, there you are. Okay, anybody any questions, by the way? Queries? Worries? Anxieties? Comments? Suggestions? Okay. Well, you know my suggestions, don't you? Must-know definitions, must-know principles. All right, good. By the way, I think for our course, you're given revision manuals, right? Have you been told that? Because I remember writing a revision manual maybe last year in which it's focused on obligations and how do you answer questions on obligations. Anyway, I'll look out for that. I think you might get that later because that's a very useful document written by a really good, written with your interests in mind. Okay, I'm going to talk about examination technique also a little bit later, particularly when we get to the revision part of the course. But remember, at the heart of good examination technique are the definitions and principles, because the definitions and principles help you identify issues. Okay? And if you're doing an examination question and you cannot identify an issue, you know what you do? Another question. Because there are issues there, you just haven't found them. Okay? And how do you find the issues? By using your tools. Okay? Definitions and principles. Okay? And then apply to the facts, arguing both sides. Okay? Because I mentioned some students say, Mr. Greenwood, if we're working through a question, they always come up to me, Mr. Greenwood, what's the answer to the question? And I said, I don't know. And they say, well, you're the teacher. You're not much of a teacher if you don't know the answer. And I said, sorry, not enough information. And I always say, did you identify the issues by using your definitions and principles? Yes, I did, just as you told me. Did you apply it to the question arguing both sides? Yes, I did, using your magic 2-letter word if. Yeah, good, well done, first class honours. Okay, all right. So that's the task you're faced with. Okay, you don't have all that much information often in a problem question. All right. Good. Lapse of time, let's not worry about that. If a time limit is mentioned in an offer, yes, and nobody replies by the time limit, okay, the offer expires, that's fine. If there's no time limit mentioned, then the offer will not be open forever. It depends on the subject matter of the contract. If it's a perishable item like bananas, I've managed to eat 1/3 of a banana today. Okay. Oh, this spelt reasonable. Oh my goodness, my eyes aren't that bad. Oh goodness. Oh, terrible. Reasonable. Delete. Where's delete? On you. Hello? You're a new one. Save changes. No such thing as a perfect PowerPoint. Okay. So I'm talking about bananas because green banana is supposed to be good for your stomach. Did you know that? But, you know, they keep right, so this one's a bit right. Okay. Okay. So it depends on the subject matter of the contract. Obviously, more durable goods than what is a reasonable time will be a longer period. I mean, I quite often offers say, this offer lasts until stocks run out, that type of thing, okay? Which is a good one, isn't it? Because the person who's making the offer can, oh, we've run out of stock, you're too late. How do you know they've run out of stock? Can you show me your warehouse so I can see what... Right. It's interesting because we're in the area of advertisements. Aren't advertisements great? Okay. Okay. And then we applied our definitions and principle to the so-called reward type cases in which there could be a notice hung on a notice board somewhere offering a reward for the return of some item, a cat, dog, smartphone, etc. Okay? And the issue will be, is that notice an offer or an invitation to treat? You know the answer, apply your definition. And if it is an indication of a willingness to be bound on certain terms, good, that's an offer. How do you accept that? Well, by performing the required act, but you've got to know about the offer. And in the Clark case, the person providing the information, because the required performance in Clark was providing information leading to the arrest of a murderer, and the Clark did that, claimed the reward, should have got the reward. But then the rather pompous High Court of Australia, which is the Court of Final Appeal, said, no, 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 you only do it to clear your name. Okay? And so they refused to give him the reward, which is a tough decision. Okay? By contrast, Williams and Carwadine, the person gave the information, the court said motive is irrelevant. Did you know of the offer? Yes. Did you provide the information? Yes. Here's your reward. Okay? That's basically it. And in Gibson and Proctor, when they actually gave the information, initially they didn't know about the offer, but they found out about the offer before it passed along to the officer in charge. The court said, good enough. Okay? Good. So a good trio of cases, these ones, if you get a reward type case in which the issue would be, has there been acceptance of the offer? Okay? And then the other issue is, can a unilateral offer be withdrawn? Yes, it can. But how do you do it? Because the offer goes to the whole world. So how are you going to let the whole world know it's being withdrawn? Well, the answer's on the screen. The US case says, in the US, you have to use a method which has the same degree of publicity, same degree of notoriety, reaches the same audience. That's another way of saying it. Okay? And that depends on the facts. Because revocation of offer itself, the top point, Errington and Errington, the father had made the promise that the young couple could keep the house provided they started paying off the mortgage installments. They started to perform the required act, which was to pay off by installments. But then the father said, no, not going to give you the house. The court said, nope, too late, they've started to perform the required act. Okay, good. Which is interesting, isn't it? Why didn't he just transfer title to them? I don't know. Luxor and Cooper is a rather special case. It is in a domestic, so it's in a commercial context in which the real estate agent claimed a reward for finding a property which the purchaser would actually purchase. And he actually started to do some work. He did show the person a number of properties, but the client didn't like any of the properties. Had the real estate agent started to perform the required act? The court said no. Because what was the required act? Finding a place he would buy. So it really depends on what exactly is the performance and when does performance begin. So in Luxor and Cooper, the offer could be withdrawn. Okay, so how do you answer these questions? Where the main issue is there agreement? And in your assignment, question 1, that is the major issue. Remember, how do you start off your answer? Hang on, I'll disappear. Come on. Oh. So in your assignment question, how do you start off? First line, your client, whatever the name is, would like to know if there's a contract between him and the other person, full stop. Next sentence, the court will look for essential elements in the formation of a contract, colon, you know what they are, agreement, consideration, intention, that's pretty well it. Full stop, next sentence. The only element in issue in your assignment question 1 will be the element of agreement. Okay? And you know the next line, don't you? Don't you? The court will analyse the existence of, not contract, a lot of students know, the existence of agreement. How? In terms of offer and acceptance, unless there are exceptional circumstances. Next sentence. There are no exceptional circumstances in your assignment question 1, full stop. So then you have to look, is there an offer? Question mark. That could be a good subheading. Subheadings are good because it helps you focus on the issue, and that's the issue. What's an issue? A question for the court to decide. So your subheading should have a hook, question mark. So that will be, is there an offer? Well, have a look. You know, apply your definition, which you know, don't you? Okay. And if there is an offer, has it been communicated to the offeree? Normally that's not an issue. Okay. And then is there acceptance? Define acceptance. And then has it been communicated to the offeror? Good. Okay. The entores, acceptance principle. Or has it been withdrawn before acceptance? Okay. That's it. So there are your subheadings. So, yeah, so I'm saying 4 good subheadings. And then you could come to some conclusion, okay? But again, it's quite often difficult to come to a black and white conclusion because you're not given sufficient information. Okay? Good. So don't panic. Okay? This is not a mathematical equation. X equals 3. No. You are lawyers. Okay? All right. Okay. So that's about as far as we got last time, I think. Certainty of terms, yes, that's important, but for our purposes, more should know than must know. The agreement itself must be clear and not vague. There's the old case of Scammell and Houston, in which a contract was held to be, quote unquote, on hire purchase terms. What on earth does that mean? Is that clear enough? It does depend on the facts of each case. And Scammell and Houston, where's that? On page 35 of your course manual. When you look at these cases, it really boils down to what my tennis student Gerald told me. He's the High Court judge, Gerald Godfrey. He was one of my good mentors He says it's a matter of common sense, the law. I said, thanks, Gerald. Whose common sense? All right. Okay. So that's Scammell and Euston, and that's page 35. Oh, previous one. Okay, there you are. The plaintiff and defendant agreed to the supply of a lorry on hire purchase terms, but the trial judge, Court of Appeal, held there was sufficient information to find a complete and enforceable contract. Okay. And the House of Lords differed, though, held that in the absence of details of the hire and purchase terms, the agreement was too vague to be enforceable. Therefore, no contract. Scammell and Euston's a good example of make sure you know what level of court you're talking about, because the decisions might change. Remember, what's the level of court of Gibson? House of Lords. Good. Is that important? Yes, it is. Why? Because the Court of Appeal came to the opposite conclusion. Okay? And as we go through, I'm going to do little quizzes. You know, what level of court is Gibson? I go through court of first instance, court of, and then Hanscott. Then I'll ask you another case. What level of court is this one? Okay? Because the level of court is important. Okay? And in Scammell and Euston, it's actually House of Lords. Which is interesting, isn't it? Because the Court of Appeal in Scammell and Euston got it wrong. But these judges are very experienced lawyers. Okay? Because, remember, you're talking about an issue. There's an argument for and there's an argument against. And somebody has to weigh up the arguments, see which one is more convincing. Who's that person who does this weighing up exercise? A judge. That's why we called him a judge. All right, okay. And then we have these other cases, Nicolene and Simmons, for example. Sometimes the courts bend over backwards because they think this is a commercial situation. The parties are acting as if there's a contract. They're indeed performing obligations. So the courts will bend over backwards to save the contract. And that's what Nicolene and Simmons is like. Contract question contained the words, "We are in agreement that the usual conditions of acceptance apply." Well, what are the usual conditions of acceptance apply? Well, none such existed, but the English Court of Appeal held that these words were meaningless and could be ignored. All right, okay. But Hillis and Arkansas is the one that goes the other way, and the court did save the contract. Should know, not must know, these cases. All right. And as I say, my last bullet point is what I've just said. If the parties have been performing obligations under the contract, then the courts will be more willing to find that there is indeed a contract. Okay. The courts like to be seen as being sort of business friendly, if you like. They want to have a pragmatic approach, so things get done. The law doesn't want to be seen as obstructing progress, if you like, particularly in business situations. Right. By the way, you should be aware of ADR, Alternative Dispute Resolution. Okay. What does that mean? Well, you don't have to go to court and litigate. There are these alternative forms of mediation and arbitration. And quite often, commercial contracts have an arbitration clause. So if there's a dispute, you go before an arbitrator who is an expert in that particular area. Hong Kong's got quite a well-known and respected international arbitration centre. It's actually in Central. Okay. And of course, Hong Kong is still a quite important business hub. So businesses like to do business in Hong Kong because we have a good legal system, okay, including arbitration and mediation for that matter. You don't want to go to court if you can avoid it. Why? It's time consuming and expensive. And the outcome is uncertain. And of course, lawyers are not cheap. Okay. But when I was practicing solicitor, I felt more like an accountant. How much time did I spend on this case? I spent 6 minutes. Okay, cool. 12 minutes on this. I remember I was in an office and there's an experienced solicitor there, and this client used to call him up, and the client was, complaining about this, that, and the other thing. I said, "Why do you put up with this guy's complaining all the time?" I said, "Well, the clock's ticking." Being a lawyer is a business, right? And in my law office, we used to have rainmakers. The rainmakers, one particular was a really handsome Chinese guy who was a really good dresser, and he circulated around, potential clients. Another guy was he was into the mahjong scene, good way of drumming up business. Okay, so these guys are in the office. They had no legal qualifications, but they were very valuable to the business, because if you don't have clients, that's it. You go out of business. Okay. All right, good. All right. But it's a noble profession. It's very, very satisfying when a client comes to you with a legal problem and you can explain it to them very clearly and come up with a solution. Okay? I remember that when I was chatting with Anna Wu. Anna Wu is quite a famous person in Hong Kong. She was the Equal Opportunities Commissioner for a while. Lovely lady. Okay? Actually worked in the same legal office for a while. She's the one who told me that. Very satisfying to solve a person's problem. A bit like a doctor. Okay. Somebody's got a problem, you solve the problem. Okay, good. All right. Actually, when I went to the doctor today, I came along prepared like a lawyer. They gave me this printout ticket. I was number 3. So I used the time available. Here is my argument. This is day 9 of my... This is what you do. You line it up in chronological order. Okay. All right. So what exactly is your issue, Mr. Greenwood? Diarrhea? Stomach problem? Flatulence? Lucky is good air conditioning. What else about it? I don't know. What was the other one I had? Okay. Well, but of course he diagnosed my problem, and the problem today was you've got stomach virus. Because I had a chronological history. Oh, you've had it for 9 days. My goodness. Certainly not food poisoning. Okay, all right. Okay. So, I mean, lawyers and doctors. Actually, when I was studying law, 2 of my colleagues were doctors, medical doctors. And I said, "What are you studying law for? You're already a doctor." So he actually became a lawyer, a barrister, specialising in personal injury cases. Okay? All right. And watch out for personal injury when we study tort law later, okay? The major tort on our course is called negligence, okay? And negligence consists of somebody owing a duty of care to somebody, and there's breach of the duty causing damage. And the damage can either be personal injury or death, or property damage, okay? All right, so when we deal with tort law later and negligence, quite often the cases involve personal injury. Okay, all right, good. Yeah. So let's finish off this for qualified conditional accept. Again, let's not worry about this too much. This is law. Should know, then must know. An agreement to an agree. Agreement to agree. Is that an agreement? The answer is no. Sometimes you see what looks like a contract, but up the top it says subject to contract. Well, that's not a contract, okay? Because it's not definite enough. Okay? But again, should know, not must know, everybody. Okay, let's get on to, I'll save the changes here. Now, second element tonight, consideration. Okay, so consideration is the second essential element in the formation of a contract. Good. What is, well, first of all, a little bit of philosophy. There is a pretty good contract law book. I mean, the course manual is pretty good. It covers everything you need to know for the course, plus more. Because remember I said it's about 100 pages too long. Okay, and of course you've got pretty good local contract law books. Okay. But there are other law books, and there's an English law book by Ewan McKendrick, who's from Oxford University. I met him once at Hong Kong U. He's a nice guy, but he says this: consideration is necessary for the contract to be given the badge of enforceability. What do you mean by that? That the parties are serious, okay? And it's based on the idea of reciprocity. What do you mean by reciprocity? When something's reciprocal, reci means back on receiving. I like doing this. Good exercise. Proceed goes forward. Reciprocity. So it's the idea of backwards and forwards. Okay. So if I'm buying your bag today, okay, how much? Nothing. Oh my goodness. Then it's a gift. Okay. And if it's a gift, there's no consideration. All right. So it's not an enforceable contract. All right. $100. 99. US, okay, US dollars. Okie dokie. So it's backwards and forwards. My money goes there, and the bag comes here, backwards and forwards. Okay. And indeed, that's the very simple definition of consideration, everybody. It's just 4 words: reciprocal, benefit, and detriment. We're coming there. But make sure you know what reciprocal or mutual means. Okay. So if you're on social media and you meet somebody for the first time, let's say you actually do meet in person, and then you send a message afterwards, okay? I mean, if you go on a date for the first time, what are you looking for after the date? A message. Because you've got their number on WhatsApp or whatever you're using, okay? And they say, "Hi, John, it was lovely meeting you today. I really enjoyed it." Okay? Well, then you wait for the reply from John, and if John says, "Oh, thank you, Mabel, the feeling is mutual," well, now you're in. You're well done. So you look forward to the second date. Okay. All right. So make sure you know what mutual or reciprocal means. Okay. We should note, the important note, you can make a contract under seal without consideration, and that's a binding contract. Why? Because you don't require consideration if the contract is made by deed under seal. Okay, so let's say, sorry, your name's Alice. I will give Alice $1 million by the end of class tonight. You've all heard it. If I don't give Alice $1 million, can you sue me for $1 million? Because I promised to give you $1 million. I'm not doing. I'm in breach of contract, aren't I? The answer is no, because she's provided no consideration. Okay. However, if we execute this agreement under seal by deed, I, Mr. Green, look, Hong Kong ID card number, promise to pay Alice, full name, Hong Kong ID card number, 1 million Hong Kong dollars in numbers and words, okay, by the end of class tonight, and it's chopped, and I don't pay her $1 million, she can sue me for breach of contract, even though she's provided no consideration. Well, I suppose listening to me, no, that's not consideration. What is consideration? Well, normally it's monetary consideration of some sort, okay, but that's an important point to make. Okay. By the way, my contract with Alice is what we call a deed of gift. Okay, a deed of gift. That's an enforceable contract. All right. So, what's the definition of consideration? It's the bottom 4 words, which are the important ones. That's why I put it in inverted commas, bold print, and underline. Reciprocal, benefit, and detriment. Okay? So, my benefit with the shy lady here is I get her bag, but that's your detriment. You lose your bag. Okay? And it's the opposite way around. My detriment is I lose my money. The benefit to the shy lady is she gets the money. So that's one way of looking at it. Okay? There are other definitions of consideration. Curry and Miser is a good case. Probably a must-know case, I think, Curry and Miser, because Curry and Miser basically gives us the bottom definition if you distill it all out. Because they say that consideration is some right, interest, profit, or benefit, underline, accruing to one party or some forbearance, detriment, loss or responsibility. Have I got that? Stop there. Given, suffered, or undertaken by the other. That's a bit of a mouthful, yes. So you can simply distill it down to reciprocal, benefit, and detriment. Okay. There's also other sort of definitions. Some people call it the price of the promise. Okay, I promised to buy the bag here, so the price is whatever the money is. Okay. And there's another one, an act of forbearance of one party or the promise thereof, which serves as the price for which the promise of the other is bought. Normally shortened to the price of the promise. Okay. But everybody must know. Our third must-know definition: reciprocal, benefit, and detriment. Dead easy, just 4 words. But make sure you know what they mean. Okay. So, some general observations about consideration. As I said, some aspects are not too difficult. Consideration must be sufficient, of some value, but need not be adequate, of equal value. You can buy an expensive car for $1 Hong Kong. $1 Hong Kong dollar. In fact, I did that in Hong Kong once. I had a very good friend who gave me his car, which was worth much more than $1. He said, because I said, John, you've got a nice Saab. And he was a good tennis playing friend of mine. He says, oh, in fact, another guy promised me his car. He said, oh, okay, you can have my car if I have to leave Hong Kong. Oh, okay. No, I'll pay for it. No, you can have it. I'll give you $1. Is that an enforceable contract? Yes, it is. Because consideration must be sufficient, of some value, but it need not be of equal value. Interesting thing about that car, the number plate was AG888. And he says, I'm going to have to take the number plate away from you. I said, why is that? Because the number plate's worth more than the car. Oh, okay. Why is that? Well, you're in Hong Kong, mate. 888, my goodness. Good. Okay. Chapel and Nestle. So next time you have chocolate, I can't have chocolate at the moment. I've been dying to have some chocolate. Chocolate's good for you, right? In small bits. Okay. Chapel and Nestle. Nestle's the chocolate company, and Nestle had an offer say, anybody who collects 10 of our chocolate wrappers can get in brand new chocolate. Okay, good. Now, what do you normally do with the chocolate wrapper? Well, what should you do? Lapse that, put it in the rubbish bin. Is it worth anything? You know, no. Well, it has a very, very small value, what we call peppercorn value. So that's Chapel and Nestle. The court said, well, the chocolate wrappers themselves were worth something, albeit very, very, very small value. That's it. Consideration must be sufficient, need not be adequate, need not be equal. Okay, all right, good. And the other aspect, which is not too difficult, what kinds of actions or promises can or cannot amount to consideration? An interesting case of Hamer and Sidway, an American case in which I think an uncle promised his nephew. Hamer and Sidway's in your course manual, yeah. Let's have a look at the facts of Hamer and Sidway on page 38. What do you think about this one? Uncle promised his nephew $5,000 US dollars. US dollars! US dollars, right? You like US dollars. If the nephew stopped smoking, drinking, swearing, and engaging in other habits. What do you mean by other habits? Until he reached the age of 21. Okay? the nephew did succeed in abstaining from these activities, and then he claimed the sum of money from the uncle. But what was the argument of the uncle? Oh, no, you have provided no consideration. What is consideration, everybody? Reciprocal, benefit, and detriment. What was the detriment to the nephew? Some people might say, well, isn't it a benefit not to smoke? Yes, it is. The world's #1 killer. Isn't it a benefit not to drink? Yes, the world's #2 killer. And isn't it a benefit not to swear? Well, I don't know about that. I'm not sure what the other habits were. But the court said that's not the point. We're talking about legal rights. It's legal to smoke. It's legal to drink. I'm not sure about it's legal to swear. Okay. So you gave up your legal rights to do these things. That's consideration. Okay? And so that's the result in Hamer and Sidway. The nephew was able to claim the money. He had provided consideration. Okay? The other issue in Hamer and Sidway we're yet to come to. The other issue in this case was there an intention to create legal relations? Because if you're in a domestic situation, the presumption is there's no intention to create legal relations. Well, this was uncle and nephew, and we'll look at that a bit later on. Okay? Some cases, there are more than one issue. Okay? That's Hamer and Sidway. Don't worry about White and Blewett. That's a case that goes the other way. And then past consideration we'll look at soon. But talking about past, the time has passed, ED, and so it's time to have our first short break. Well done, stomach. We made it to the first hour. Not stomach, it's the other one. Right. So we'll have a 10-minute break. After the break, we'll carry on with these aspects of consideration. Okay, so I hope you had a good little break. I got my chamomile tea. So before the break, talking about consideration, looking at the aspects which are not too difficult. Okay. Why can consideration need has to be sufficient but not of equal value? Well, the courts are not going to get into the bargaining process. The bargaining process is a matter for the parties to decide. Okay. And then Hamer and Sidway is a good case. All right. Hamer and Sidway, I think, must know. There have been questions in past papers based on the facts of Hamer and Sidway. I remember the nephew gave up his legal right to smoke, drink, etc. Okay, and so that was a detriment. And the fact that it was probably a benefit to him physically is irrelevant. Okay, it's the legal benefit he gave up. So that was his detriment. Okay, and then past consideration, interesting case on past consideration coming up. Adequacy Insufficiency. I've given you this extra PowerPoint saying what I've already said. Thomas and Thomas is an interesting case, probably worth mentioning a little bit. Thomas and Thomas there are facts in that case in which some of the actions were not consideration, but the court did find that there was consideration on other facts of the particular case. Trying to find where I've got that. Okay. Adequacy Insufficiency. Yes, I've added in Thomas, yes. Remove. Whenever you see a case name with the same names, you know it's, well, usually a family law case, but this case is just a different relatives, okay, with the same name. So Thomas and Thomas on page 39, prior to the testator's death. Who on earth is a testator? Somebody who has made a will. So hands up those in this room who have made a will. Nobody in this room has made a will. So if you were to die today, heaven forbid, you will die intestate. Sounds painful, but means dying without having made a will. So what's going to happen to your estate in Hong Kong? It will pass according to the Intestate Estates Ordinance. So if you've got nothing to do on your way home tonight on the Mass Torture Railway, MTR, you might want to have a quick look at the IEO. Have a look at section 4 of the IEO. That's how your property will be divided up. And if you don't like the way it's divided up under section 4 of the IEO, what do? Make a will. Okay. So this is what happened here. Somebody died prior to the testator's death. He expressed his desire that his widow should have one of his houses for the rest of her life. Well, what an awful husband. If you're married, you should own the matrimonial home jointly on a joint tenancy. What does that mean? It's a form of co-ownership which gives the holder a potential right to the whole property. A potential right to the whole property. Okay? Until the other person dies, you have nothing. But if the other person dies, you've got the whole lot. Okay? So when I bought my flat in Tung Chung, I said to my wife, let's own the property as joint tenants, both at law and in equity. This is land law, okay? And I said, well, I had to explain to my wife, who's not a lawyer, what on earth is a joint tenant? It's a form of co-ownership. More than one person owns the same piece of property at the same time, which gives the holder a potential right to the whole property. It's not yours yet, okay? If you die first, what happens to the property? The right of survivorship comes in, it passes to the surviving joint tenant, okay? So that's exactly what happened. So when my wife died, guess what, everybody? So it's just me and the cockroaches and the weevils, except I try to kill those. Okay, yeah, so, I mean, this, I think, affects everybody in this room. I mean, presumably at one stage you'll be married, or I was going to say in co-ownership with somebody, okay? And of course, when you're married, married life is really pretty good, except for one thing, money, okay? Fighting over money, and I mean, there's a famous case in Hong Kong, the minibus driver case. He was married, and life was great. He made a lot of money. He gave it all to his wife. Thank you very much. And other people say, well, my wife and I have a very good agreement about money. I earn it and she spends it. That sounds very sexist. Could be the other way around. So, I mean, you need to, talk about these things and sort them out. Now, the matrimonial home is the most valuable asset probably you will have. And so you should sort this out before you die. But they didn't do it in Thomas and Thomas, okay? He should have owned the property jointly. So if he dies, it automatically goes to his wife, full stop, automatic, okay? Of course, what you have to do is to register the death certificate of your former spouse at the land registry in Hong Kong. I've done that. So when I sell my property, the person who buys the property said, hello, this property was owned by you and your wife. What's happened to your wife? I said, well, check the registry. You find there's a death certificate there. Okay? That's how it works in Hong Kong. All right. So there you are. Thomas and Thomas. But in 1842, I mean, things were different, all right? Women got a raw deal, okay, treated like second-class citizens. But that's what the case was. So here, so prior to his death, he expressed his desire his widow should have one of his houses. Well, why don't you just give her one? Sounds like he's rich. One of his houses. How many have you got? This desire was not reflected in the will of the testator. So he made a will but didn't put it in his will. Okay. After he died, his executors promised to carry out the testator's wish and provided that the widow pay £1 per annum towards the ground and the keep of the house in good repair. Yeah, fine, okay. But why should you have to pay anything? Right? And it's also a good example of consideration need not be adequate as long as it's of some value. Okay? So that was the consideration in Thomas and Thomas, the payment of £1 per annum. His wishes was not consideration. By the way, who's an executor? An executor is the person named in a will. Okay? And so when there's a grant of probate, the executors take over the running of your estate. If you die intestate, the people who take over your property are called administrators. So collectively, executors and administrators are called personal representatives. Must know, by the way, because when we get to tort law, we deal with situations in which the plaintiff has died. Well, can the plaintiff sue if he's dead? No. The person who sues on his behalf will be his personal representatives. Okay, good. Okay, so Thomas and Thomas, a good case. Okay, but he should have just owned the property jointly with her, or simply given her the property. Okay. And by the way, £1 per annum back in the 18th, which actually could have been a lot of money, all right? You think, you know, £1, that's nothing. Anyway, and then of course, Thomas and Thomas, consideration must be sufficient, but need not be adequate. Obviously, paying £1 per annum is not exactly the same as the value of the house. Presumably, it's a decent house. Okay? And of course, Chapel and Nestle, next time you have your chocolate, think twice before you throw away the wrapper. Okay? I mean, in Hong Kong, we used to have this Keep Hong Kong Clean campaign. And so Hong Kong's pretty good with rubbish bins. Have you noticed that? Have you been in another city, you know, the world? You go forever looking for a rubbish bin, or when you do find one, they're overflowing. I mean, Hong Kong's not perfect, but our rubbish bins are not too bad. They're normally quite brightly coloured, green or whatever. So think twice before you throw it away. But in Hong Kong, this Clean Hong Kong campaign, they had a cartoon character called Lap Sat Chung. Remember Lap Sat Chung? But Lap Sat Chung actually, everybody liked Lap Sat Chung. He was a cute little bad guy. And so the whole campaign backfired. They had to fire Lap Sat Chung. Because he's supposed to be a bad guy you don't follow, but end up following you. Oh, he's a cutie. Look what oh, Mummy, look at Lap Sat Chung. He's thrown, let's throw the rubbish. Well, they had to rethink that campaign, didn't they? What's the current catchphrase in Hong Kong? I don't know. Let's fight the virus. Oh, that's pretty good. At least they haven't got some stupid cartoon character. So what's on the screen, everybody? Must know. And I say probably Chapel and Nestle is the important case, because that's the famous one. So there you are. Hang on, where's my past consideration? Oh, okay. Oh yeah, I haven't got, for some reason, it's not my past consideration. Past consideration, this last bullet point, I think I've got it further on here. I've got out of order. Yeah, let's talk about past consideration. This is PowerPoint 8. Yeah, all right. But we'll come back to the I think my PowerPoint's I could probably juggle the order a bit more. But let's talk about past consideration. What is past consideration? You do something and the other person say, well done, now I'll pay you for it. Well, that's not good consideration. It is past consideration. And the general principle with regard to past consideration, it is not good consideration. Full stop. Take your pick, either Roscola and Thomas or Revocation. They're both on page 42. Okay. Must know. So that's a principle, yes, a very simple principle. Past consideration is not good consideration. However, if the act done was at the request of the promissor and the parties understood it would be paid for, then that will be good consideration. Now, this is the case of Lampley and Braithwaite, and it is not a misprint. It's not 16:15, it's not 4:15 in the afternoon. No, it's the 17th century England. In England in the 17th century, who had the power? The reigning monarch, who were king or queen. Okay? Absolute power. So what happened in Lampley and Braithwaite? Braithwaite was sentenced to death. Okay? In the 17th century, they were pretty quick at executing people. All right? So Braithwaite didn't want to die. I'm too young to die. Okay. So he went to Lampley and said, hello, can you do something, can you get me a pardon from the king? And so Lampley went along, somehow or other got an audience with the king and got Braithwaite a pardon. And you can imagine the reaction of Braithwaite when Lampley came in. Oh, hello, how did you go? How was it? Yeah, you got your pardon. Oh, what? You got it? Oh my goodness. Wow, I'll give you £100. And then refused to pay. So Lampley sued him, breach of contract. Was there good consideration? Braithwaite argued, past consideration. I've read the book, past consideration. But Lampley said, hang on. Was the act done at the request of Braithwaite? Yes. Did the parties agree that the act would be paid for? And Lampley said, you bet your life, because what I was doing was very dangerous. I'm going before the king. And if the king had a bad day, like an upset stomach, he could probably, oh, go away, chop his head off. And the head drops down. And won the day. The court agreed. Okay? He wasn't doing this for fun. He was putting his own life at risk. The parties had agreed this would be paid for. This was good consideration. Okay? So that's Lampley and Braithwaite. Confirmed by, there's a case there called How On and Lao Yu Long. Hong Kong case. Okay? And How On PC. What is PC? No. Police constable? No. Politically correct? No. PC is Privy Council. Privy Council was the court of final appeal in Hong Kong before the handover. Now when you think about it, it's pretty ridiculous. When the British were in Hong Kong up to 1997, if you were going to the Court of Final Appeal, you didn't go down to Central in that lovely old building like they do now. You had to pack your bags and fly to London and appear before the Privy Council, which was basically the House of Lords. Okay. But that's gone, so since the handover, Court of Final Appeal is in Hong Kong. Okay. So How On is Privy Council, a la House of Lords, which of course in England now. So it's the highest level court. And How On's an interesting case, and also it confirms the Lampley and Braithwaite case. Right? And How On is a rather interesting but rather complex case, and it's authority for a number of issues. Okay? And you know what an issue is. A question for the court to decide, and they decided here and power on, confirm, Lampley and Braithwaite, okay? Among other issues. Okay. Recase's patent says the same thing. Oh, I like this chair. The reason is, everybody, is that I was teaching yesterday, and because it was online, Adobe Connect, don't you just love it? Except when it breaks down. No microphone today, sir. You'll have to shut it down. Oh, thanks very much. And I had to sit sort of rigid. My back got really stiff. Okay. But this is good. Oh, if you like a good massage. Do you like a good foot massage? I always have foot massage, neck and shoulder. Oh my goodness, I could do with one now. Okay. So, yeah, what was I talking about? Oh, I'm getting distracted. Contract means draw together. Distracted means drawn away. And when you like somebody, attracted. Okay. Nice chair, well done. They spent a lot of money on this room. Well done, Space. I like the equipment. You're bent back at the 30-degree angle. Remember when you're good posture when you're in front of your PC? It should be tilted back. Hello, you're 30 degrees. Looks a bit like it. Wow. Good. So my PowerPoint's looking even better these days with this U-Butte screens and things. Okay, so everybody, what's on the screen? Yes, must know. Why? It comes up in exams. Probably part A, half a question, 10 marks. Explain whether past consideration is good consideration, or the past consideration principle. Well, the principle's dead easy. Past consideration, past. Oh my goodness, sound like Joe Biden. Actually, poor old Joe, he had some speech defect when he was younger, right? And then everybody's mocking him like that awful Trump guy. Sleepy Joe. I'm not sleepy, no. I'm going to take my waker-upper. Okay. So must know the principle. Past consideration is not good consideration, full stop. However, if the act was done at the request of the promisor and the parties, P is parties, understand that payment would be made, don't worry about the promise being legally recoverable, that's by the by, then that is not good consideration. Sorry, not past consideration, that is good consideration. Watch out for those expressions. Good consideration means valid consideration, same thing. Okay. All right. This Reese Casey's patent's not in your course manual, but how on Lampley and Braithwaite's actually on page 43. Well done. The facts are reasonably clear. Okay. So his promise was enforceable. Okay. Oh, Reese Casey's patent's there too. Yeah. And I like Lampley and Braithwaite because that's dramatic facts. Sounds like something out of a movie. Okay. Right. I mean, there's been quite a lot of movies about English kings and queens, all right? Remember that case with Kate Blanchett playing Elizabeth I or something else? And then Queen Victoria, for heaven's sake. Victoria Harbour. We are in Victoria at the moment, aren't we? We're in Victoria, Hong Kong Island. Isn't that lovely? You go all over the world, there's always a Victoria. Oh, we've got Victoria Park. Right. Victoria, she was an interesting lady. This next PowerPoint should know, not really must know. It says that consideration must move from the promisee. In other words, the parties to the contract provide the consideration, not somebody else. Okay? And it does link with what we call the doctrine of privity of contract. What does that mean? So if I have a contract between me and the shy lady, sorry. Okay. Then I can sue her for breach of contract. See, she can sue me for breach of contract because we're parties to the contract. There's privity of contract. That's basically what that means. Only the parties to a contract can sue or be sued. Okay. There is recent legislation in England and even more recent in Hong Kong which has reduced the application of this doctrine of privity of contract to a certain extent, in that now a benefit can be conferred on a third party, in other words not a party to the contract, but you can't impose a burden on a third party. So there's a legislation which we'll cover briefly when we cover privity of contract later. It's called the Contract, in brackets, Rights of Third Parties Ordinance. And it was only fairly recently enacted, late 2000s. Okay. Consideration and motive, we already covered this. Remember, wishes don't matter, it's actual consideration, must have some value. Okay, everybody, now on to the tough bits. Performing an existing contractual duty. Is that good consideration for extra payment? That's basically what it is. So we have three cases: Stilk and Myrick, Contrast, Hartley and Ponsonby. And then, most importantly, everybody, Williams and Roffey. Williams and Roffey is a must-know case. Comes up regularly in exams. It's not an easy case, but once you know the facts of Williams and Roffey, then not too bad. Okay, so let's go through Stilk and Myrick and Hartley and Ponsonby. You find them on page 48. In Stilk and Myrick, you notice the years, early 19th century. So you've got, this is where the year is important because you've got to appreciate the surrounding circumstances. Now, if you're a sailor at sea in the 19th century, good luck, because, you know, a good percentage of the sailors died before completing the voyage, either from accidents or illness, like scurvy, lack of vitamin C. Oh. This Gatorade's a good teaching aid, right? So in Stilk and Myrick, sailors on board a ship, they sail from port A to port B, and some of them got ill, and so they're on their way to port B, and so the captain promised the remaining fit sailors, all right, you lot, I'll give you extra money to complete the voyage. They completed the voyage, claimed the extra money, and the captain said, no consideration. You're performing your existing duty. You signed up and you were being paid for sail from port A to port B, that's it. You have provided no consideration for the extra payment. What is consideration, everybody? Reciprocal, benefit, and detriment. So where is the detriment for the extra payment? There is none. You're performing your existing duty. Okay? And the court agreed. By contrast, in Hartley and Ponsonby, ship sails from port A to port B. Then the sailors got ill. Now, have you seen Johnny Depp in Pirates of the Caribbean? You know what sailors do when they're on board, when they're ashore, right? They go absolutely berserk. They get drunk, etc., etc. And so a lot of the sailors got drunk or couldn't complete the return voyage. So then the captain promised the remaining fit sailors extra money for the return voyage, and the court said that's all right. They broke it up into two contracts. Okay? And so that's the difference between Stilk and Myrick and Hartley and Ponsonby. So the court said there are two contracts in Hartley and Ponsonby, and so the promise of extra payment for the return voyage, that was good consideration. Okay? But there's not a great deal of difference between the two cases, so it's a good pair of contrasting decisions. They are both House of Lords. They are both early 19th century. The facts are similar, but not the same. and the conclusions are opposites. Okay? But Stilk and Murray is the leading case, saying performing your existing duty is not good consideration for extra payment. All right? Because there's no detriment suffered by you. Therefore, no consideration. That's the important point to get. Okay? And remember, you understand this by knowing the definition of consideration. All right. Good. Now, Williams and Roffey. Let's go through Williams and Roffey. Now, this looks like a long PowerPoint, and it is. On pages 48 to 49, particularly 49. So let's go through this. And this is must know, everybody. I know it's a lot, but we're going to cover this in a bit of detail. So Williams and Roffey, look at the year 1991. We're in the 20th century. Do you remember the 20th century? That was the last one. Court of Appeal decision, must know, must know. And in this particular case, the court said that performing an existing duty under a contract can be good consideration if the following conditions are satisfied. Okay? Now, looks a bit complicated, but what I've tried to do is to put in bold print the key issues. The first point is that this will only apply if it's a contract for either sale of goods or provision of services. That's the first point to make. This restricts the application of this decision. The second and third points come from the facts of Williams and Roffey. Now, Williams and Roffey, you have an existing contract. Main contractor, subcontractor. So the terms are clear, okay? And the terms were that the subcontractor complete a number of building units at a certain price by a certain time. Good? Perfectly valid contract. But after a certain time, it became clear that the work was behind schedule, and so the main contractor approached the subcontractor and said, wow, you're behind schedule. I will give you extra money to complete on time. Okay? Now, why was the main contractor worried? Well, because this deadline was important, because if the deadline wasn't met, the main contractor had to pay a penalty fee. Okay? All right. So the work was completed on time, so the subcontractor said, okay, where's my extra money? The main contractor said, aha, no consideration. You're performing your existing duty under the contract. Good argument. It's like Stilk and Murray. Okay? But the court said, hang on, this can be good consideration if the other requirements are satisfied. Was there an extra benefit to the main contractor? Now, this is very controversial and a little bit uncertain. What do you mean by the extra benefit to the main contractor? And if you read textbooks on this, is it factual benefit? Is it practical benefit? What is it? Good question. It really boils down to pragmatic, taking a pragmatic approach. The work gets done, so this is a benefit to you. Projects get completed, like that White Elephant Road to Macau. Okay, all right. So in the road to Macau, there are a lot of delays and a lot of those projects. Very similar issues. Okay. And the other point is, we'll actually look at economic duress later. But economic duress basically means this. You make an unlawful threat to be in breach of contract by not sticking to the original terms of the contract. Okay? And the other party has no practical alternative but to agree. Okay? that could be what we call economic duress. And basically, it means you're not entering into this agreement voluntarily. Okay? And we'll look at the elements of economic duress soon. I have to actually go to another set of PowerPoints. And in Williams and Roffey, the court didn't find there was any economic duress. Okay. All right? But the big problem here is, what is this extra benefit to the main contractor? And as I say, a lot of the cases simply say, well, there's a benefit in getting things done. That's good enough. Okay? And remember, what is consideration? Reciprocal benefit and detriment. Okay. So the subcontractor may have suffered no extra detriment, but there's extra benefit to the main contractor. That's the issue. That's the justification. But this is a very controversial case. But it's very much alive and well, both in England and Hong Kong. Okay? All right. So let me sort of give an example here. Sorry, your name's? Henry. I'm the main contractor, you're the subcontractor. All right? Role play. Are we up for it? Henry looks pretty good. So Henry comes to me, so you're saying you need extra money to complete this job, right?
I need extra money to complete this job.
But we've got an agreement. What's the point of having an agreement if you want to... I guess I've got no alternative. All right, okay. Is that economic duress? No. Nobody likes paying more than before, okay? But that's not economic duress, okay? This will be, okay, let's start again. So, Henry, you want extra money for completing this particular job?
I need extra money to complete.
Yes, okay. But we've got an agreement here. I mean, you've given me no alternative here. You've painted me into a corner, all right? I am forced to accept this, otherwise I can't perform, okay? Let's have a meeting. I'm recording all the minutes of this meeting, and I'm reserving all my legal rights. That could be economic duress, okay? You are arguing that this agreement for the extra money is not enforceable because of economic duress, okay? And as we'll see when we get to vitiating elements, duress makes a contract voidable at the option of the innocent party, okay? And if you are alleging economic duress, you've got to prove it. So in my second example with Henry, I can prove it. I've got evidence in writing. I attended a meeting with Henry in room 204, Admiralty Centre, okay? I said, I don't like the fact I've got to pay you extra money. You made it very difficult for me. I have no practical alternative but to agree. I'm reserving all my legal rights. That's good evidence to prove economic duress. Okay? All right. So the law has distinguished between the rough and tumble of normal commercial bargaining, which can be quite vigorous but still lawful, legitimate. And then on the other hand, illegitimate bargaining, okay, which is economic duress. Okay. So that's the last point, which limits the application of Williams and Roffey. Okay. Now, this is a little bit of a subtle point, but let's see if I can make it. Now, in Williams and Roffey, it was the main contractor approached the subcontractor. All right. And a lot of people, and economic duress was not pleaded in the case. And so the court didn't actually hear this issue. But you might be able to argue that in Williams and Roffey, there may not have been express economic duress, there's implied economic duress. So let me give an example. Okay. Oh, I can't move that. Oh, that's not good. I want to put my feet up. That's not good. All right. Okay, let's say, everybody, you're a subcontractor and you're tendering for a very valuable contract. What might you do to get the contract? You bid a very low price. which gets you the contract. Good. And then you know Williams and Roffey. So what do? Well, after the contract's entered into, you got your mask on. Right, okay. I normally put, anybody here from Thailand? Because it's culturally sensitive to show your, I normally put my feet up and sort of go to sleep for a minute. Actually, that'd be a good idea. Okay, I'll just sit back and do nothing. He's going to come to me and offer me extra money for doing the same job. Everybody get the point? You bid a very low price to get the contract, and now you're doing nothing, and that's sort of forcing him, economic duress, to pay you extra money. And the criticism here is it encourages inefficiency, it encourages bad building practices. Okay? And indeed, this is the criticism of a lot of the contracts for building the road to Macau and Zhuhai. And there are quite a few cases came before the Hong Kong courts on this. Right? So everybody thinks in Williams and Roffey they should have pleaded economic duress, but they didn't do it. Okay. Right, so these are slightly subtle points, but once you know the facts of the case, not too bad, all right? Now, you could get a question on Williams and Roffey in the exam, and it could be the full 40-mark question in Part B. But if you know the facts of Williams and Roffey, and you know what's on the screen, not too bad, okay? So, there's an existing contract between the parties, but it has to be a contract for either sale of goods or provision of services. Why is that? Good question. This will become clearer when we deal with a very important case dealing with, which gives a principle that we'll look in a moment, is that part payment of a debt is not good consideration for the whole debt. And there is a House of Lords case called Folks and Beer which says that. And so contracts for payment of a debt, Williams and Roffey does not apply because there's a House of Lords case which says the opposite. Okay? All right. So that's the first restriction. The points 2 and 3 come from the facts of Williams and Roffey. Okay? And then the fourth point is the curious bit. What on earth is this extra benefit to the main contractor? Isn't the main contractor entitled to expect the other person to perform their obligations? Yep. So where's the extra benefit? Good question. And the courts haven't come up with a satisfactory explanation of what this is, except to say the job gets done. Roads to Macau get completed. All right? So you can see the courts adopting a pragmatic approach of getting things done. Okay. And then the last point is a little bit unfair on you at the moment because we actually haven't studied duress. But duress is a doctrine at law, and duress renders a contract voidable at the option of the innocent party. Okay? So I held a gun to your head last time, right? Yes? You can't remember? I never hold a gun to the head of a lady. That seems very unfair. It's normally a guy. Okay. I mean, if you force somebody to enter into a contract through threat of violence, that is duress, and it renders the contract voidable at the option of the innocent party. I emphasise voidable as opposed to void. If a contract is rendered void, it terminates automatically. But duress renders a contract voidable, which means what? It carries on until the innocent party elects to terminate it. Okay? And so duress renders a contract voidable at the option of the innocent party, and economic duress has the same effect. Okay? Economic duress, a bit more subtle form of pressure. You're not holding a gun to somebody's head, but you're putting them under illegitimate pressure. Okay? All right, good. So what I want to do is, if I can, jump ahead to economic duress and talk about that. and then I want to come back to the important point about number one. Well, maybe, hang on, what's the order of my PowerPoint? Yeah, let's jump ahead to, not that one, this one. Okay, everybody. Tonight, you have added one more tool to your definitions, it. Consideration is reciprocal, benefits, and detriment. Good. Also, one more principle. Part payment of the debts is not good consideration for the whole debt. And my almost parting gift to you tonight, aren't I generous? Another must-know principle. Part payment of the debts is not good consideration for the whole debt. Okay? I emphasize the word debt. So this is a contract for payment of a debt. It is not a contract for payment of goods. It's not a contract for provision of services. Okay? You might say, well, what's the distinction? Good question. There is no real logical distinction, but that's the distinction the law is making here. Okay? So let's talk about folks and beer. Shall we do it now? I think probably good to have the second short break, because folks and beer is an important case, and folks and beer may make you a little bit thirsty, but watch out for the beer. So we're going to talk about folks and beer. Folks and beer is a must-know case, and it's important to note it's House of Lords. Because folks and beer lays down the principle, part payment of a debt is not good consideration for the whole debt. Okay? Right, so let's have our second short break.
整上嚟起身啊！
Okay, everybody, into the final stretch.
I can understand the difference between practical benefit and good consideration.
Good question. Nobody knows. Question from the audience. What's the difference between practical benefit and good consideration? Good question. And remember those 5 points on Williams and Roffey? Okay? Williams and Roffey is a very, very controversial case, but it's only Court of Appeal. So if it's a Court of Appeal decision, it can be overruled by the House of Lords or legislation. Okay? But remember what the word law means. That which is laid down. So the law has been laid down in Williams and Roffey, and it's still good law today. Okay? So good case from your legal training point of view. Okay? So a case remains good law until it's overturned. Has not been overturned yet. It is still the law both in England and Hong Kong. All right? And it may well be overturned, who knows? And so this is why I've given you those 5 points. So let's quickly go back to them. I'm building up to explaining why the first point. The first point about Williams and Roffey is it only applies to contracts for either sale of goods or provision of services. It does not apply to contracts for payment of a debt. And the reason is part payment of a debt is not good consideration for the whole debt. So the law is now distinguishing between contracts for sale of goods and provision of services on one hand, and contracts for payment of debt on the other. It's an illogical distinction. There are lots and lots of articles on this case. What's such a bad case? Why is it still the law? Because it has not been overturned. Okay? All right? And so you have to distinguish between contracts for sale of goods, provision of services, and contracts for payment of a debt. That's the first point. That's why I put goods and services in bold print. Okay? And so you might want to make a little cross-reference. See boats and beer. Okay? The second and third points are on the facts of Williams and Roffey. Okay? And then the fourth point is what the lady's talking about. As a result, the main contractor obtains a benefit. Well, what benefit? Good question. The main contractor said, well, where's the benefit to me? Aren't I entitled already to have the other party perform their duties under the contract? Yes, you are. So where's the extra benefit? Good question. The courts haven't satisfactorily explained it. Okay? The only sort of close approximation is on page 50, in that if you go to the third paragraph, there's a case called UBC Construction and Sung Fo Ki, decided by, my goodness, by my former tennis student, Neil Kaplan. Yes. He's the one who got me into law, by the way. He's the one who turned me from a tennis coach into a lawyer. So you've got him to blame for me. But he gave this decision in this case. He says, in this particular case, the court said that there was no economic, actually it's more on the economic duress point, but he did say that there was a benefit here in that the work got completed. A practical benefit, if you like. Things get done. You don't want projects hanging up in the air, half finished. You want to get them done. Okay? So that's the explanation. All right? Okay. And of course, there's a point to that, I suppose. Okay? You want to get things. I mean, Hong Kong's pretty good at finishing projects. When I first came to Hong Kong, there's only the Cross Harbour Tunnel. Now we've got 3. And then, of course, the Ching Ma Bridge and the Lantau Link which at one time was the world's biggest civil project. Did you know that? If you go down to Central, by the way, there's that little building there where they're showing these video presentations that revolve every 50. Gives the development of Hong Kong. It's really impressive, okay? But the way Hong Kong has gone ahead infrastructure-wise. I mean, again, go to another city and see if they've got better infrastructure. Go to Manila, for example. Oh my goodness. Bangkok. Oh. So there you are. Now, so things get done, all right. But is that still good law? Are you encouraging bad practices? That's the criticism. Okay. And in that case, UBC, it was actually stronger case for economic duress because it wasn't the main contractor approaching the subcontractor. It was the other way around. The subcontractor said to the main contractor, "Give me extra money or I won't finish." Well, that's more like economic duress. Okay? Right? You're putting pressure on the other person. Okay. So that's why we've got the fifth point. Okay. But the fourth point is really the most unsatisfactory part of this. What do you mean? What is this benefit? And the cases say factual benefit, practical benefit. What is it? Good question. All right. And then, in fact, that's what Mr. Justice Kaplan, to give his proper title, said, the practical benefit is, well, the job gets done. Isn't that a benefit to everybody? Okay. Not much point of having a project that's not finished. Okay. I mean, you go some cities in Asia, oh, that's a lovely flyover. How come it's finished in mid-air? Doesn't happen in Hong Kong, does it? Okay. And of course, that road to Macau is fantastic. I went on it once. I mean, the road, wow. Brand new buses and all the rest. When I got to Macau, I made the mistake of taking a bus. Should have taken a taxi. I mean, buses in Macau are incredibly crowded. Anyway, that's by the way. When will we be able to go to Macau again? I don't know. I used to like going to the Grand Lisboa. It had a really good buffet, 24-hour restaurant there. Anyway. And the Star Hotel, where they had these really elegant hostesses. I used to call them giraffes because they were very tall ladies in the high heels. Hello, sir. Welcome. Please come to our casino and spend your money. All right. Okay. Poor old Macau now with all the mainland visitors holding back. They must be feeling the pinch. Okay. All right. So Williams and Roffey, everybody, a very controversial case. I'm not saying it's an easy case, no, but it's very good legal training, okay? Because it does explain what the law is, which is laid down. Everybody thinks, well, if Williams and Roffey is badly decided, why don't we overturn it? Well, maybe, but not yet, okay? But, and why do we distinguish between contracts for sale of goods, provision of services, on one hand, and contracts for pay? Good question. No logical distinction, except Williams and Roffey is only Court of Appeal. Folkes and Beer is House of Lords. So let's go back to Folkes and Beer. So what happened in Folkes and Beer? So I'm going to talk to you folks over a beer. No, except I don't drink. No. I don't drink or smoke or swear, but I'm not a boring person. Actually, I'd love Saturday nights are a great time for going out, having a good time. All right, I can't really even do that now because I can't eat. All right, just study my contract law. That keeps me entertained. All right. So, Folkes and Beer, there's a contract for payment of a debt by Mr. Folkes to Mrs. Beer. Okay, good. And it consists of now, whenever you borrow money, there's the principal to repay and the interest. Okay, good. By the way, interesting in England, literally, you could not charge interest in England until about the mid-1850s, when they brought in the Usury Act. Before that, charging interest was illegal. Okay. Mind you, interest these days is so low, although credit card companies do very well, don't they? When we get to unconscionable contracts ordinance, there's a very interesting case involving credit cards, okay, which I think affects everybody in this room, okay? And it just shows you how much interest these credit card companies charge you, okay? I mean, I looked at my credit card statement today. Okay, you can borrow extra money, only 36% interest. What? 36%? You're joking. I get 0 on my savings account. How come you can charge me 36%? Anyway, so there you are. So Mr. Folks owed Mrs. Beer principal plus interest. Now, he couldn't repay the whole lot at once, so they agreed he could repay the principal, emphasise the principal, 50% lump sum, the other 50% by instalments. Okay? So he paid off the principal, and then he said to Mrs. Beer, okay, I've paid off the principal, can you now declare me debt-free? And she said, no, you still owe me the interest. And the court agreed. Part payment of a debt is not good consideration for the whole debt. That's the principle, okay? And it's House of Lords, okay? And when you think about it, this is what happens in Williams and Roffey, okay? It's part payment of a debt trying to be good consideration. Okay, but there are exceptions to this principle, and notable exceptions. If you pay in a different form, that can be good consideration. Or if you pay earlier than you have to, that's detriment, that's consideration. So if you have to pay by the end of the month and you pay by the 20th of the month, that can be good consideration. Also, if somebody else pays the debt for you, that can be good consideration. Okay, we actually haven't covered that point. So you've got a principle, if you like, the part payment principle, but there are notable exceptions to it, and that's the second bullet point. Okay. The D&C Builders and Rees case, interesting one. Denning saying payment by cheque is the same as payment by cash. I disagree with that. I mean, if somebody owes me money, I'd rather have cash rather than a cheque, because cheques might bounce. I don't know. Okay, it depends on the amount involved. And then Williams and Roffey, not applicable, N/A, and that was confirmed in a English case called Re-Select Move, which said, hang on, Williams and Roffey cannot apply to contracts for payment of a debt because of the part payment principle. Folks and Beer is House of Lords. A Court of Appeal decision cannot override a House of Lords decision. Okay? So these are good cases in which the level of court matters. Okay? All right, everybody. Quick quiz. What level of court is Gibson? Who says first instance? Court of Appeal? House of Lords? I know you've got to put your hand up. Next question. What level of court is Folks and Beer? House of Lords, right, that's it. What level of court is Williams and Roffey? Court of Appeal. Must know. Must know. Okay? But the principle itself is quite easy to state. Part payment of a debt is not good consideration for the whole debt. Good. But there are notable exceptions, and I pose the query at the bottom. Again, this practical benefit point. If somebody owes you, I don't know, 50,000 Hong Kong dollars, and they say, you know, I'm going through tough times because of COVID-19, will you take 40,000? Well, most people today would, yeah, okay, 40,000, no problem. But that would not be good consideration for the whole debt. So you could argue, hang on, isn't it a practical benefit? Because I might go bankrupt and I can't owe you anything. 40,000 is a damn sight better than nothing. All right. So you can see this practical business argument emerging here but with relation to debt rather than goods and services. Okay? All right. And of course, we're in Hong Kong, one of the world's leading financial centres. This is pragmatic financial operation. Okay. Good. What a lovely chair this is. Can I take you home? I mean, it saved my back. I mean, because of my stomach, my back gets really stiff. So when I walk down the stairs to the mass torture railway, if I'm moving slowly, you know why. But normally I'm very quick. I go up the stairs, everybody. I don't take the escalator, and I do it 2 at a time. I can still do it. Okay? Because on my hikes, my way to Discovery Bay, 1,100 steps up. Okay? Pretty good. So someone said, hang on, you do that? You must have thighs like iron rods. Yeah, okay. There you are. Okay. So my feet are good, my arms are good, my head's going. Hello? And my stomach gone. Okay, well, all right. Enough about you. Get on with it. Okay. So there you are. This is the query. Isn't part payment actually a benefit to a creditor? Good question. And the law in England is leaning towards this. They are saying, well, hang on, perhaps Folks and Beer, we should do away with it. So Folks and Beer is under pressure in England. The pressure in the courts is to say Folks and Beer is wrongly decided, which is interesting. All right. Okay. All right. Now let me go back to this particular point. Obligations owed to third parties, that can be good consideration. So watch out for, and this is the case of Shadwell and Shadwell, page, where are we, 46. Because one of the exceptions to the part payment principle is that somebody else pays you. That can be good consideration. So in Shadwell and Shadwell, you've got the facts there on page 47. An uncle promised his nephew, who was getting married, a sum of a lot of money in those days, £150 a year, until the nephew's annual income as a barrister reached 600 guineas. Isn't that lovely? The uncle had paid 12 instalments when he died, so the nephew sued the uncle's estate for specific performance of the contract. Sounds logical. It was argued on behalf of the uncle's estate that the nephew provided no consideration. The nephew said that his consideration was getting married. He was going to get married to Ellen. He was saying, in consideration of you marrying Ellen, which I think was one of the relatives of the uncle, I will pay you this extra money. Doesn't reflect that well on poor old Ellen, doesn't it? Sounds like she's hard to marry off. Well, marry Ellen and I'll pay you extra. Right? So that was the issue. And the court said that was still good consideration. The consideration was entering into a separate contract, namely marrying Ellen. Sounds very unromantic, but in those days, when you married somebody, you entered into a contract. And they used to take it very seriously. If you didn't marry the person you were engaged to, that was breach of promise and you could be sued in a court of law. So everybody was very careful about getting engaged in those days, because once you're engaged, you're virtually married. All right. Okay. So there you are. That's Shadwell and Shadwell. The nephew was already contractually bound to marry Ellen, and provided good consideration for the uncle's promise of payment after he married her. Okay. And this was confirmed by these other cases, Scottson and Pegg, and in particular by our old friend Pow On and Lau Yu Long. Okay. Privy Council, you know what Privy Council is, right? Okay, good. Pow is a very famous Hong Kong name, isn't it? When I first came to Hong Kong, YK Pow was a big shipping magnate. Okay. And don't worry about the Eurimited, but it's actually mentioned in on page 47, says the same thing. Okay. So entering into another contract can be good consideration for that particular contract. Okay. And this is why in part payment of a debt, that's one of the exceptions to the part payment principle. So Remember the exceptions. Payment in a different form, because that could be a benefit to the creditor. Earlier payment obviously is a benefit to the creditor. Our payment by a third party, that is good consideration because of what we've just covered. Okay. So what's on the screen, everybody? Good PowerPoint. Lots packed into this PowerPoint. But the must-know principle, everybody, is part payment of a debt is not good consideration for the whole debt, unless you've got these exceptions. Okay. And as I say, Folks and Beer is under threat by the courts in England now, who's saying, you know, we think Folks and Beer has had its day, and there are good reasons for abolishing it. Okay? All right. Okie doke. So that's that. Very quickly, this one. This is all should know, not must know. Performance of a duty imposed by law. It sort of makes sense. If that a policeman is performing his existing duty, then he shouldn't be entitled to extra payment, because this could amount to some form of corruption. So first, the case of Collins and Godfrey. Godfrey promised to pay Collins 6 guineas for giving evidence in a case for Godfrey. Well, policemen's supposed to do that. Okay, so the court held there was no consideration given by Collins that permitted enforcement of Godfrey's promise. He was a subpoenaed witness. He had to give evidence anyway, required by law to give evidence. And then there are exceptions, though. The Glasbrook and Glamorgan County case, where the defendant was owner of a coal mine. A strike broke out at the mines. The defendant sought help from the police to keep the peace. Well, they're doing their duty, aren't they? But the police suggest the provisions of a mobile group. Defendant insisted that police officers should be on duty at the premises, promised to pay these officers on duty. And in a way, in effect, the duties performed by the police were way over and beyond their normal duty. So that was special services provided, can be good consideration. Okay. Ward and Byam is an interesting case. Ward and Byam's on page 45. This is a Lord Danning case. Lord Danning is a very liberal judge. He used to find consideration where nobody thought consideration existed. So let's have a look at Ward and Byam. Father of an illegitimate child promised to pay the child's mother £1 per week, provided the child was well looked after and happy. Well, mothers are supposed to do that, aren't they? Look after the child and keep them happy. It's a demanding job. I mean, watch out for any mother with children. Again, you always notice them on the MTR because they're the ones running around and climbing up the poles. Okay, Johnny, don't do that. But kids like to do that sort of thing. It's a demanding job looking after young children, absolutely. Okay, and but wasn't she performing existing duty? Because when the father failed to make payment, the mother sued the father. Father argued the mother was in any event under a legal duty to look after the child, to take care of the child, and therefore provided no consideration. Well, Lord Danning was having nothing of that. He said there is consideration. He says, it was true that the mother provided no consideration by performing her legal duty, but the father benefited by the mother's promise to look after the child, just as would have benefited if a neighbour had promised to look after the child. This is what we call stretching the boundaries of consideration. Okay? All right. In fact, the word used here is the court's inventing consideration. They want to find there's a binding contract, and so they invent consideration. So there is a binding contract. But Danning has been severely criticised for this because everybody thinks he's wrong. Okay. But Ward and Byam has followed in other cases like Williams and Williams on page 46. Okay. the plaintiff wife deserted her husband, the defendant. It was agreed that the husband was to pay a small amount per month as maintenance, provided the wife was this is a good one, chaste. It's C-H-A-S-T-E, not C-H-A-S. No, that's a joke. She was chaste, maintained herself. Oh dear ladies, have you been maintaining yourself? This is very sexist. And did not pledge the husband's credit. When the husband failed to make payment, the wife sued to enforce the maintenance agreement. The court agreed, okay. Denning heard the case. Of course, he's on the side of the wife, found there was consideration. I mean, the court's supposed to be unbiased. Remember Madam Justice holding the scales of the law. She's blindfolded, okay, wearing a long dress. But whenever there's a poor lady being badly treated by a woman, sometimes the scales are tilted more. I mean, the law's supposed to be, not biased, but okay. So you've got a long extract there on page 46. All right. So but again, pretty well all these cases on the screen, everybody should know, not must know. Okay. There are a lot of cases on consideration, and I've indicated the must-know ones already tonight, and when we review this on Thursday, I will tick off all the must-know cases. All right? Okay, good. All right, how are we doing? We've got that. Oh my goodness. It's getting late. How late is it? This is a really difficult area of law, promissory estoppel. Let me give you the facts of the High Trees case in which promissory estoppel came. Again, a Lord Denning decision. But the facts are interesting because they're going to apply today. Because what happened in the High Trees case? We have a contract between landlord and tenant. Good? In London, Second World War. Okay? You've seen the movies, right? I saw Dunkirk. I was in a very cold theatre for some reason, but that sort of made it even more realistic, okay? When, what's his name? Charlie Stiles, or whatever his name is, the famous guy from England. He's a singer, right? Terry Stiles. Harry, yeah. He's supposed to be a handsome star, right? I'm not a lady, but I suppose. Okay, when he's been shot at by the Germans, and you had all these big. All right. I was in the army, you see, so I like these war ones. Did you know that? I was in the army, straight up, captain. I was drafted to go to Vietnam to fight the Viet Cong. All right. And I could have, my name came up, I was drafted. I said, I've got to do my national duty. I could have got out of it by pleading flat feet, but I sit on my heels every night. I've got really good arches. This is why I walk quickly. And so Hong Kong's got a really good war history, okay? You know the two lions in Central? Stephen and Stitt, okay? When the Japanese and the Americans bombed Hong Kong, 1944-45, the shrapnel damaged the two lions, okay? So if you were to look closely at the lions, if the security guard will let you, you see the shrapnel bits. But then, of course, Stephen and Stitt were damaged by the protesters last year, so they boxed them up, and now they were unveiled fairly recently. Okay? I mean, that's in Central, underneath the Hong Kong Bank building. Right? So there you are. Hong Kong was invaded, occupied by the Japanese for a while. Right. So, what was I talking about? Get on with it. What am I talking? Hello, I better check my PowerPoint. Oh yeah, the High Trees case. We're in the Second World War, okay? Now the landlord said to the tenant, I know it's tough, we're in a war, and the landlord owned a number of units. So he said to this particular tenant, don't worry, you don't have to pay the full rent, 50% will do. Until when? Until I can let out all the other flats. Okay? And the period between making that promise to reduce rent and let out all the other flats is called the estoppel period. Okay? Now everybody thinks, well, that means the end of the war, right? But no, the Brits knew they were going to win the war, 2 or 3 months before the official end, because the Americans had come in, all right? And so the Americans were flooding England. This is why England had left-hand drive ambulances. Okay? There's actually a case we study in tort law on that. Right? And so the estoppel period wasn't actually the end of the war, it was a few months before the end. And then the landlord said to the tenant, okay, I can let out all the flats, I'm now going to charge you the full rent. Could he do that? Good question. The answer is yes, he could, by giving reasonable notice, which I think was 1 month, because rent was on a monthly basis. Okay? That sounds quite good. The big question, though, is what happens to the balance between the full rent and the half rent during the estoppel period? Can the landlord get all of that back, or is his right to the balance extinguished? Now, if the right is extinguished, that runs counter to Folks and Beer, which says part payment of a debt is not good consideration for the whole debt. Okay? All right. So this is very controversial, the High Trees case, which we'll go through, not tonight because it's getting late, and my brain fade is setting in a bit earlier tonight. Okay. You're awake though, that's good. Yep. By the way, when you go to sleep, when you wake up early in the morning, your brain's very fresh. And you find, aha, I understand what he's talking about now. Right. So, interesting. Let me sort of, I know I'm going to finish a bit early, but I'm fading a bit here. Hope you don't mind. You don't mind if I finish 5 minutes early also? And of course, this is difficult going right at the moment. And when we deal with this again on Thursday, you'll find Williams and Rocky not too bad. Once you know the facts, once you know the definition of consideration, which is reciprocal benefit and detriment. Was it the subcontractor performing his existing duty? Where is the extra detriment suffered by the subcontractor? There is none. But the Court of Appeal said there was, but on strict conditions, so to speak. All right? And let's face it, in Williams and Rocky, there was no consideration. The court simply wanted to find there was, and they really almost made it up. Okay? All right. So stick to your definitions. The definition of consideration helps you understand Williams and Rocky. What's this all about? Why is it controversial? Okay? So this is why Williams and Rocky is controversial. Seems to say you can do away with the need for consideration in certain circumstances. You've got to have a completed contract, yes, but if the terms are varied, you don't need consideration for changing the terms of the contract. Okay? You always need consideration in the formation of a contract, but after Williams and Rocky, you don't need consideration for the variation of the contract. Okay? So Williams and Rocky is controversial for that point, and so is the High Trees case. But the High Trees case is even more controversial because it says in certain circumstances, part payment of a debt can be good consideration for the whole debt. Well, that runs directly counter to the House of Lords decision in Folks and Beer. Okay, good. So let's finish off with quick hands up, everybody. What level of court is Gibson? First instance, Court of Appeal, House of Lords. Good, well done. Next question. What level of court is Williams and Rocky? First instance, Court of Appeal. Oh, good. This is important. All right, I asked you this one, a little bit unfair, but it will show you how controversial this case is when we deal with it in more detail next time. And by the way, the doctrine of promissory estoppel is should know, not must know. Williams and Rocky must know. Promissory estoppel should know. But it's a good instructive case because it deals with the court using its powers in equity. Okay, what level of court do you think High Trees is? Are you ready? Who says House of Lords? Have a guess if you're wrong. Who says Court of Appeal? Who says First Instance? You're all wrong. It's only First Instance. You say, well, what on earth are we talking about a First Instance case, which is what, 70 years old, which runs counter to Folks and Beer and seems to run against the idea that you need consideration for the variation of contract? Good question. So you think Williams and Rocky is controversial, High Trees is even more controversial, but it's still good law today. It's good law both in England and Hong Kong. As recently as 2009, the Court of Final Appeal in Hong Kong has approved the High Trees principle, okay? The doctrine of promissory estoppel. Now, remember, the doctrine of promissory estoppel is a doctrine in equity. Have I made that clear? I haven't, but I should. And when you're in equity, the equitable principles apply. Delay defeats equity, and he who seeks equity must do equity. The so-called clean hands doctrine. Okay? All right. And it's instructive to go through the High Trees case again and try to rationalise what the decision is all about, because it will help you get a good grasp of the distinction between being at law and in equity. Now, one of the big differences between being at law and equity is this. Breach of contract, your normal remedy is damages, and the remedy is a remedy at law. Easy, done. What is damages? Money. Equity, though, is more flexible. The remedies in equity are much more flexible. The saying is, equity will mould the remedy to fit the equity of the case. The court will come up with a remedy to, if you like, a fair result. Fair means equitable, etc. Okay? So this is why the remedies for promissory estoppel vary. In some instances, the right of the landlord to the outstanding debt is merely suspended, he'll get it all back. But in other cases, the right of the landlord to the balance is extinguished. And that's very controversial because that runs counter to Folks and Beer. Okay, good. So, as you pass out the door and you ask yourself, what did I learn today? You learned the past consideration principle. Past consideration is not good consideration. But note Lampley and Braithwaite and power on. Also, you know the definition of consideration, reciprocal, benefit and detriment, and you know the part payment principle. Part payment of a debt is not good consideration for the whole debt. House of Lords, Folks and Beer. Okay? Well, excuse me. Oh, that's the chamomile tea. Well, folks, I think that's. I'm actually quite proud of myself for getting this far tonight. I was really in an awful state. No, shut up about yourself. Okay. So when we meet again on Thursday, we'll review, in particular, Williams and Rocky. We'll go through promissory estoppel, okay, and that will finish off consideration. Then we'll cover the rather shorter topic of intention to create legal relations, which is a very easy, short topic. Okay. All right. So my suggestion is read ahead, and my other suggestion is have a safe journey home. Okay. And I'll see you all on Thursday. Thanks for putting up with my moans tonight. I'll be better on Thursday.
Thank you so much, sir.